as someone who has been the architect of sanctions laws impacting Iran and Russia and North Korea, I understand how important it is to prevent criminals and sanctioned individuals from anonymously accessing the financial system. Therefore, it's critical that we improve beneficial ownership information to understand exactly who benefits from a legal entity. I think there's been some discussion about that from what I gathered before, and ensure that information is quickly available to law enforcement. In May, Treasury's new customer due diligence requirements for financial institutions are going to go into effect. There's been some testimony here about the nature of that in terms of banks having to identify and verify beneficial owners owning 25% or more of a legal entity, as well as an individual on the management team. Some witnesses expressed concern about Treasury's implementation of these regulations. Some suggested that there's not an actual 25% or more stake, there'd be no one to list as a beneficial owner. Ms. Mandelker, can you address these concerns and provide some additional detail on how Treasury plans to implement this new regulation?
Well, again, as you mentioned, Senator, the rule is going to go into effect in May. I know a lot of financial institutions are already have been taking steps underway to make sure that they're complying with the rule. In addition to the 25% beneficial ownership mandate, companies are also going to have to identify who a controlling person that's resident within a particular entity. So it's not just the ownership trigger; it's also the controlling person that needs to be. So
whether or not there's sufficient to establish a 25%, the controlling person will have to be identified.
A control person will have to be identified as well.
Do you think that that will give you the breadth and scope necessary to make sure that we know who is the beneficial entity?
I think it's a very important step. Of course, that's information that's going to go to the banks. So that it's a requirement that the banks identify and verify who the beneficial owners are and who a controlling person is, and of course, to the extent, and then we'll have the ability to obtain information as necessary and in the right circumstances from the banks.
All right, let me follow up on both Senator Warner's and Donnelly's questions on cryptocurrencies. I'm interested in your view on the use of virtual currencies by foreign sovereign states like Russia and Venezuela to evade sanctions. In recent months, both Venezuela and Russia have expressed interest in state-backed virtual currencies. In December, Venezuelan President Maduro announced he is launching a virtual currency backed by the nation's oil reserves for the explicit purpose, as is stated, of circumventing sanctions imposed by the United States. Now, perhaps lack of technological sophistication will delay or hamper this plan, but we know full well that Maduro will use every tool at his disposal to perpetuate his authoritarian objectives. So it's critical that we understand the risk here. Do you believe that the Treasury Department is monitoring these developments, and do you have the technical tools and enforcement mechanisms to combat the use of cryptocurrencies to evade U.S. sanctions?
So we are monitoring the developments. As I'm sure you're aware, we've had a very active portfolio in the context of what Venezuela is doing, in addition to a very strong executive order that the president issued in August. We've also been designating individuals who have enabled the Maduro regime to and committed what we think are a variety of different types of offenses. When it comes to the resources and tools to make sure that we're monitoring virtual currency and cryptocurrency, we do have a dedicated team of individuals at Treasury who have the expertise to monitor these activities very carefully and closely. We are regulating this industry, which is very important. We are examining virtual currency exchanges along with the IRS.
My question is, okay, so now I appreciate and I'm glad to hear that you're monitoring it, but do you believe you have the tools and mechanisms necessary in place to combat the use of cryptocurrencies to evade U.S. sanctions?
We do have tools and authorities in place to make sure that we are staying very much on top of this burgeoning industry.
Nothing that you need?
At this time, no, Senator.
Okay.
There's
I'm
not.
Glad to hear that. Finally, I'm sure you're aware that FinCEN issued guidance in 2014 to clarify Bank Secrecy Act expectations and set the rules of the road for banks and financial institutions seeking to provide services to legitimate marijuana-related businesses in states that have legalized. What I have heard, including from New Jersey institutions for which medical marijuana is legalized, and now the state is considering the possibility of passing, legalizing the essence of recreational marijuana, is that there is a concern that according to the Pew Charitable Trust, since the guidance was issued, the number of banks and credit unions serving businesses in the industry have more than tripled to nearly 400. Regardless of my views on this, if it's going to be legal in any state, I think it should be bankable and transactionable, and we should be able to have eyes on it and understand revenues and how the money is flowing. FinCEN's guidance has been critical to alleviating some of the public safety risks as well in terms of accumulation of large quantities of cash at dispensaries and businesses. And I worry that any steps to walk back this guidance only serve to undermine public safety. So can you commit that this guidance is going to stay in place?
We are reviewing the guidance in light of the Attorney General's recent decision to revoke a Justice Department memorandum on this issue. What the guidance did was it provided guidance to financial institutions with respect to what kinds of SARs they should file in different circumstances. The laws with respect to the Controlled Substances Act, of course, remain on the books. Those haven't undertaken any changes that would have to be done by the Congress.
Well, but when you're saying you're reviewing, does that mean that you find a conflict with FinCEN having the standards for banking transactions in states where the law permits these sales to take place or uses to take place, and that you see there is a conflict with it that would lead you to say, no, you can't bank them anymore?
I'm not suggesting that there's a conflict or not a conflict. The guidance remains in place, and we're taking a look at it in light of the Justice Department's announcement.
Would you let us know if you move to change it?
Yes, of course, we would let you know.
Thank you, Mr. Chairman, for your courtesy.
Thank you. And